Good morning. Hey guys. It's a lazy Saturday. And we are going to cover what we didn't get to cover yesterday because we were watching the Colin Griffith trial. And we are going to start out by, if I can get my computer and my lousy internet to cooperate, we are going to start out with reading the decision from the Daubert hearing. Remember the Daubert hearing that I streamed about Dr. Marie Russell, who is the dog bite expert. Let me see. I can share my screen. Now, I can only make that bigger so you guys can see it. Nope, that makes it smaller. I'm trying, guys, I'm trying. Okay, can you guys read that? I think you can. Looks like you can. Because I can read it. Here, let me make it a little bit bigger. Okay. Commonwealth versus Karen Reed. Get my mic closer. Make sure you can hear me. Memorandum of Decision and Order on the Commonwealth's motion to exclude the testimony of Dr. Marie Russell. Before the court is the Commonwealth's motion. Hey, Draco. Before the court is the Commonwealth's motion to exclude the proposed expert testimony of Dr. Marie Russell. Dr. Russell intends to testify as to whether the abrasions on John O'Keefe's right arm were caused by a dog. The Commonwealth contends that the defendant has failed to show that her testimony meets the requirements set forth in Daubert v. Merrill Doe Pharmaceuticals, Inc. and Commonwealth v. Lanigan. The court conducted a Daubert-Lanigan hearing on December 12, 2024 and January 7, 2025. Although a close question, the court will deny the Commonwealth's motion. Discussion. Before a witness can provide expert testimony, the court, as the gatekeeper, must keep a preliminary determination that the testimony has satisfied the requirements for admissibility. See Commonwealth v. Hines. Expert testimony is admissible when the testimony concerns matters beyond the common knowledge of the jurors and will aid the jurors in reaching a decision. Commonwealth v. Frangipane. Good Lord, what kind of name is that? Expert testimony is inadmissible, however, when the witness testifies to matters beyond her area of expertise. See Commonwealth v. Rentala. The determination of admissibility is within the court's discretion. See Commonwealth v. Robinson. However, before the court may exercise its discretion to admit expert testimony, the party seeking to offer the testimony, here the defendant must establish 5 foundational elements. 1. That the expert testimony will assist the trier of fact because the information is beyond the common knowledge of jurors. 2, that the witness is qualified as an expert in the relevant area of inquiry. 3, that the expert's opinion is based on facts or data of a type reasonably relied on by experts to form opinions in the relevant field. 4, that the theory underlining the opinion is reliable. And 5, that the theory is applied to the particular facts of the case in a reliable manner. Here, the recognition of dog bite wounds is not within the common knowledge of a layperson and requires expert testimony, and Dr. Russell is a qualified expert as to these topics. She is a board certified emergency medical doctor with over 30 years of experience, is trained in forensic pathology, and has conducted over 500 autopsies. With respect to dog bites, specifically, Dr. Russell has treated hundreds of wounds resulting from dog attacks during her time as an emergency room doctor and co authored peer reviewed articles on the treatment of law enforcement canine bites in the emergency room. Lastly, in forming her opinion in this case, Dr. Russell conducted a differential diagnosis based on the pattern of the victim's wounds and their characteristics and supported her theory with references to peer reviewed publications. Use of differential diagnosis is a standard scientific technique of identifying the cause of a medical problem. Accordingly, the court finds that Dr. Russell's testimony satisfies the five foundational elements and therefore will be allowed Dr. Russell to testify as to whether the abrasions on John O'Keefe's right arm were caused by a dog. In so ruling, the court recognizes that on cross examination, the Commonwealth demonstrated, among other things, that Dr. Russell's expertise primarily concerns the treatment, not the identification of dog bites, that her evaluation of the abrasions failed to consider all available information, that she has not compared the abrasions with the dentition of the German Shepherd in question, and that her opinion is inconsistent with findings that there was no canine DNA in the area of the victim's clothing near the abrasions. However, the court concludes that these issues go to the weight of Dr. Russell's testimony, not its admissibility, and can be addressed during cross examination at trial. C. Hines. In evaluating admissibility, a judge does not determine whether to credit the expert's ultimate opinion. Order. For the foregoing reasons, the Commonwealth's motion to exclude the testimony of Dr. Marie Russell is denied. Beverly J. Canoni. January 13th. Oh, she signed it on my birthday. So, yeah, she threw a little shade in there at the end, but we've got Dr. Russell. Yay! So that was the decision after the Daubert hearing for Dr. Russell. Now, I don't know what happened to the motion. I probably have it, but I don't know where it is. The motion to exclude Green. I think that is what the hearing is that we're going to watch. But this is the defense's opposition to Commonwealth's motion to exclude certain testimony of defense witness Richard Green. So are they just wanting to do, it looks like from this, defense opposition to Commonwealth's motion to exclude certain testimony of defense witness. So it doesn't look like they want him completely out altogether, just certain testimony. That's weird. Commonwealth of Massachusetts versus Karen Reed. Now comes the defendant, Karen Reed, and respectfully requests that this honorable court deny the Commonwealth's motion to exclude the expert testimony of Richard Green as to 1. His expert opinion that a Google search for how long tie dye in CIKD or Haas long to die in cold was made on Jennifer McCabe's phone prior to 6:23 a.m. on January 29th, 2022, and 2. His expert opinion that Jennifer McCabe's phone incurred user deletions of any data related to Google searches, and deny the Commonwealth's included request for an evidentiary hearing under the standards set forth in Daubert v. Merrill Doe Farms and Commonwealth v. Lanigan. The Commonwealth has not made any showing that the qualifications or methodology of Mr. Green do not satisfy Daubert Lanigan. Instead, the Commonwealth's entire motion merely addresses the conclusions and opinions of Mr. Green, matters that courts resoundingly state are the subject for cross-examination and the jury, not the narrow function of the Daubert Lanigan judicial gatekeeper. Moreover, as this opposition clearly demonstrates, Mr. Green is eminently qualified and his methodology pertaining to the subject matter of the instant motion is reliable. As a result, in addition to denial of the motion, no evidentiary hearing is justifiable. The motion of the Commonwealth to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach of the Commonwealth to deny. I'm sorry, that was amazing. I can read that again. The motion of the Commonwealth to exclude the trial testimony of Richard Green is just the latest in the Gatling gun dystopian approach of the Commonwealth to deny Miss Reed the ability to present her defense through her well credentialed method methodologically reliable expert witnesses so she can have a fair trial against the baseless charges lodged against her. The expert witness of the defense here, Richard Green, testified as an expert witness in digital forensics in the first trial regarding his opinion that the Google search, "a house long to die in cold," existed in the data from the iPhone 11 of Jennifer McCabe with a timestamp of at or before 2:27:40 a.m. and in a deleted state. 2:27:40 a.m. search artifact without any objection from the Commonwealth to his qualifications or methodology. And for good reason. Mr. Green has been accepted in several United States courts as an expert in digital forensics. The methodology that Mr. Green employed in the first trial was the same methodology that the proffered experts for the Commonwealth employed. That is, Mr. Green and the two proffered experts of the Commonwealth received the same raw image file from Jennifer McCabe's iPhone 11, verified the hash signature / value of the image file, took the image file and saved it to their computers, servers, hard drives, etc., and then processed and evaluated the image file with the appropriate tools such as Celebrite, Analyzer, and Magnetic Forensics Axiom. While Commonwealth witness Ian Whiffen used only the Celebrite Physical Analyzer and ArtX tools, Commonwealth witness Jessica Hyde historically used 3 more tools than Ian Whiffen, and Richard Green used at least as many tools as Jessica Hyde, with Green and Hyde using 4 of the same tools. Notably, although Jessica Hyde previously used 4 of the 5 tools used by Richard Green in her initial analysis, all but Celebrite are now disconcertingly absent from her December 2024 report submitted with the Commonwealth's motion, despite her admonitions in her previous report that it is best to use multiple tools. What? So she's changing her method now? What? Importantly, it was undisputed by all expert witnesses at the first trial that the 2:27:40 a.m. search artifact was indeed present on the iPhone of Jennifer McCabe after analysis using Celebrite Physical Analyzer forensic technology available and on the marker at the time. It is thus completely inexplicable how the Commonwealth can now challenge the methodology of Richard Green, whose methodology is the same as and then more comprehensible than that of the digital forensics witness of the Commonwealth. It is the opinions and conclusions, not the methodology of the witness that differ, but that difference is not a Daubert Lanigan issue. No, it's a truth issue. What has changed since the first trial? The answer is disturbingly Orwellian and brings the prosecution closer to, if not squarely within, the danger zone of legal tyranny. After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement centric digital forensic consultant, appears to have gone back to his company, Celebrite, to have its researchers perform further updates to its physical analyzer programs, such that the artifact containing the 2:27:40 a.m. timestamp has now suddenly disappeared from all Celebrite programs. What? After the first trial, the proffered expert witness for the Commonwealth, Ian Whiffen, a law enforcement centric digital forensics consultant, appears to have gone back to his company, Celebrite, to have its researchers perform further updates to its physical analyzer programs, such that the artifact containing the 2:27:40 a.m. timestamp has now suddenly disappeared from all Celebrite programs. See January 2025 Green affidavit at 6. The 2:27:40 a.m. search artifact has now nefariously become, without explanation, the Orwellian unperson. After Celebrite completely rid itself of the 2:27:40 a.m. search artifact, that is incredibly inconvenient to the theory of the case of the Commonwealth now comes before the court saying the unilateral and unexplained Celebrite updates to remove the 2:27:40 a.m. search artifact should control whether a jury is able to evaluate whose digital forensics theory about the artifact is more accurate. And in doing so, glaringly, the Commonwealth does not address the other forensic tools, such as magnet forensics axiom that Ms. Hyde used in 2023, that Mr. Green used in the first trial and continues to use up to this day, and that still contains and shows the 2:27:40 a.m. search artifact, nor the several other digital forensic tools that Mr. Green used. Additionally, the motion of the Commonwealth is legally insufficient on its face. The motion is not supported by one affidavit. The motion does not even begin to meet its going forward obligation to state how Mr. Green is now suddenly, after the first trial, supposedly not qualified. Nor does the motion even begin to identify what the Commonwealth believes is the proper methodology to address the 2:27:40 a.m. search artifact, or why the methodology employed by Mr. Green to analyze it is not reliable. Perhaps this failure is due to the fact that Mr. Green is eminently qualified, including more qualified in data forensics than Mr. Whiffen, and that the methodology of Mr. Green employed includes the same and entire methodology of the proffered witness for the Commonwealth, plus his addition of additionally accepted digital forensic tools. To prevent the continued abuses of Miss Reed by the Commonwealth, including the bleeding of her financial resources and distractions from her and her defense team's preparation for trial, the invasion of the province of the jury, and other broader jurisprudential maladies, this court must deny the Commonwealth's motion and its included request for an evidentiary hearing. Case history of the digital forensics analysis of the 2:27:40 a.m. search artifact. For 3 years in this case, there has been no dispute over the methodology employed by the defense to address the issue of the 2:27:40 a.m. search artifact. On June 21st, 2024, Richard Green testified at that trial as a defense expert without any obligation as to his qualifications or methodology. The use of digital forensics took to analyze. Hey, just. On June 21st, 2024, Richard Green testified at that trial as a defense expert without any objection as to his qualifications or methodology, the use of digital forensic tools to analyze data on the raw image file. As he stated in that testimony, after receiving the raw image file of the data contained on Jennifer McCabe's iPhone 11, Mr. Green used 5 digital forensic tools to evaluate and analyze the data on the image file. Celebrite Physical Analyzer, Magnet Axiom, Belkasoft X, Sanderson Forensics, SQLite, Forensic Explorer, and ArtX. See January 2025 Green Affidavit. I can't say that word. Affidavit. Commonwealth Motion X3 Green. We're going to go over his affidavit after this. Through the use of these 5 tools, Mr. Green found that the 2:27:40 a.m. search artifact existed and appeared in a deleted state. Those findings were consistent with the April 24th, 2023 report of Trooper Nicholas. I'm having trouble talking. I'm sorry. I don't know why. Those findings were consistent with the April 24th, 2023 report of Trooper Nicholas Guarino, who testified as a proffered expert of the Commonwealth in the first trial. Mr. Guarino reported that while the 2:27:40 a.m. search artifact did not appear on the version of Celebrite Physical Analyzer he had used for his May 4th, 2022 analysis of Jennifer McCabe's iPhone data, Mr. Green had used the then newest version of Physical Analyzer, which did depict the 2:27:40 a.m. search artifact. The newest version was able to pull an artifact in the browser state, DB wall file, Hoslong to die in cold, at 2:27:40 a.m. on 1/29/2022, deleted. Inexplicably and unexplained up to this day, Trooper Guarino did not disclose in his report of April of 2023 that the Axiom program he used at that time did show the 2:27:40 a.m. search artifact. Mr. Green's findings were further consistent across all 5 tools that he employed and remains consistent with findings as of January 2025 from analysis performed in the most recent version. of Axiom, which continues to report the 2:27:40 a.m. search artifact. Like Mr. Green, Mr. Whiffin's methodology was to use digital forensic tools to analyze the raw image file of data from Jennifer McCabe's iPhone. Unlike Mr. Green, however, Mr. Whiffen used only two digital forensic tools in his analysis of the data: Celebrite Physical Analyzer, his company's tool, and Ardex. After performing an analysis using a then on the market Celebrite Physical Analyzer program, Mr. Whiffen testified at the first trial and reported that he had seen the 2:27:40 a.m. search artifact. See defendants Whiffen test something. So the 2:27:40 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record, depicting the 2:27:40 a.m. search artifact. Thus, while he disagreed with Mr. Green's opinion about whether that information indicated a search for House Long to Die in Cold was conducted at 2:27:40 a.m., he did not dispute that this 2:27:40 a.m. search artifact was present and in a deleted state during his analysis. Jennifer Hyde also employed this methodology, originally using Celebrite Physical Analyzer, Sanderson Forensics SQLite, Axiom RX, and iLeap. Four of these tools were amongst the five used by Mr. Green in his analysis. In her May 2023 report and in her testimony at trial, Ms. Hyde agreed with Mr. Green and Mr. Whiffen that she had seen the 2:27:40 a.m. search artifact during her analysis. In the instance of the Google search How Long to Die in Cold that was recovered with a timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted. She also admitted in her May 2023 report that the 2:27:40 a.m. search artifact appeared in a deleted state. She agreed with Mr. Green's opinion about whether this information indicated that a search for a House Long to Die in Cold was conducted at 2:27:40 a.m. She did not dispute that the 2:27:40 a.m. search artifact was present during her analysis. Inexplicably, Ms. Hyde changed her analysis and findings from her May of 2023 report to align with Mr. Whiffen. To align with Mr. Whiffen after a Celebrite manipulated update to one physical analyzer program, which the defense learned about approximately 1 week before trial began. Magically remove the 2:27:40 timestamp value from record source from the Safari's browser state. Using only this updated Celebrite tool and no others, Ms. Hyde drafted a new report in December 2024, taking back without explanation her original conclusion that the artifact containing the 2:27:40 a.m. timestamp was present on the iPhone of Jennifer McCabe in a deleted state. She opined instead that the artifact containing the 2:27:40 a.m. timestamp was not present in a deleted state or otherwise, citing merely an unsupported, conclusory, and scientifically insufficient assertion that the timestamp was not reliable. Like Mr. Whiffen, neither Miss Hyde nor the Commonwealth explain how the update occurred on any scientific reason for the change, or any scientific reason for the change. The Commonwealth simply makes the same bald conclusory statement as Miss Hyde, that further research shows that the timestamp is not a reliable source for a timestamp relating to the URL shown. Commonwealth, that's another citation. The Commonwealth provides no explanation for that assertion, nor does it provide any information as to the reasons why that supposed research allegedly finds a 2:27 a.m. search artifact and that this artifact alone is unreliable. It also provides no information that the methodology of that research or any other information regarding what changes were made, how, or why. Critically, despite the manipulation associated with this unexplained update and the accompanying sudden change in the analysis of the Commonwealth's proffered experts, Ms. Hyde. All right, Alita, dang. I usually burp. Today I'm burping and yawning. Critically, despite the manipulation associated with this unexplained update and the accompanying sudden change in the analysis of the Commonwealth's proffered experts, Ms. Hyde's second report, dated December 2024, does not represent a different methodology, but rather a narrowing of and change in opinion about the presence of the 2:27:40 a.m. search artifact. In this second report, she employs the same methodology as she did in the first trial and as Mr. Green and Mr. Whiffen employed, but deletes mention of an inconvenient axiom tool she used in her May 2023 report, which, as of the date in this opposition, continues to show the artifact containing the 2:27:40 a.m. timestamp in a deleted state to reach a different conclusion. The only difference, in fact, between the application of the methodology by the Commonwealth's proffered experts and the application of the methodology by Richard Green, that the former is entirely encompassed by the latter. Mr. Green simply used more tools in employing the same methodology and thus was able to conduct a more thorough forensic data analysis. The appropriateness and reliability of Mr. Green's all encompassing methodology is evidenced by the fact that all experts agreed. Sorry, guys. Sorry. All experts agreed and opined at some time during the first trial that the 2:27:40 a.m. search artifact existed and appeared in a deleted state. Mr. Green's methodology is further supported by Jessica Hyde's testimony that it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis. And that doing so is absolutely pertinent and allows her to ensure that she's getting the most complete interpretations. This mimics the approach of Mr. Green and is counter to the myopic and company biased approach of Mr. Whiffen, to which Miss Hyde now disquietly has morphed. The experts' disagreement is not over the methodology, but rather their opinions on whether the 2:27:40 a.m. search artifact indicates that Jennifer McCabe conducted a search for Hoslong to die in cold at or before 2:27:40 a.m., contrary to the assertion of the Commonwealth. This is a paradigmatic battle of the experts. Argument 1. The court should deny the Commonwealth's request to exclude Richard Green's testimony concerning the 2:27:40 a.m. search artifact. The motion of the Commonwealth is deficient on its face. The Commonwealth's motion to exclude certain expert testimony of Richard Green is deficient on its face in the two aspects of Daubert-Lanigan applicable to this motion. The Commonwealth claims that Mr. Green is not qualified and that his methodology is unreliable, but provides no explanation as to why. In fact, the Commonwealth does not even describe the methodology of Mr. Green, which it asserts is unreliable and seeks to exclude. Excuse me, that was a burp. I'm burping and yawning both this time, y'all. don't know what's happening. Too much air and not enough at the same time. this 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 is insane, you guys. They're not playing fair. Hey Judy, this is not fair. They have updated the Celebrate program to somehow exclude the deleted artifact of the 2:27 a.m. text or search. And now Jessica Hyde is only using the Celebrate program and nothing else after she said it's important to use multiple programs. Is everybody stupid? Can no one look at this and see how blatantly obvious it is that they're trying to pigeonhole this woman as, I don't want to use the word frame, but pigeonhole this woman as the person that did this? I mean, come on. You'd have to be blind to believe. Of course, the jury doesn't know any of this stuff. Because, of course, if they did know it, they would absolutely decide to acquit. I mean, geez. Now I lost my spot. The Commonwealth's motion is not only bereft with respect to the two apt prongs of the Daubert-Lanigan inquiry, qualifications and reliability of methodology, but also with respect to other aspects of its analysis. Nowhere in the motion does the Commonwealth discuss the general acceptance precept of Commonwealth v. Davis or the non-exclusive factors of Daubert. What little the Commonwealth does say about the law is rote and does not address the question at issue here. The Commonwealth also fails to mention that Commonwealth v. Rentala instructs that the crucial inquiry for Daubert-Lanigan purposes is whether the proffered expert is qualified. Mr. Green overwhelmingly satisfies the Daubert-Lanigan standard. And the motion of the Commonwealth is not supported by any affidavit. An affidavit detailing all facts relied upon in support of the motion and signed by a person with personal knowledge of the factual basis of the motion shall be attached to all pretrial motions. The Commonwealth additionally misses the point of a Daubert-Lanigan inquiry. It argues, for example, that Mr. Green's opinions as to the artifact containing the 2:27:40 a.m. timestamp lack any evidentiary support, cannot be made in good faith, constitute baseless claims. These claims, in addition to being false, have no relevance to the methodology inquiry. They relate only to cross examination and jury determinations, which means it's not a Daubert issue. B. Even if the motion of the Commonwealth was not deficient on its face, Mr. Green easily meets the requirements of Daubert-Lanigan. Broadly, the Daubert-Lanigan inquiry involves evaluation of both the qualifications and methodology of the proffered expert. However, the crucial issue in determining whether a witness is qualified to give an expert opinion is whether the witness has sufficient education, training, experience, and familiarity with the subject matter of the testimony. In addition, under Daubert-Lanigan, the judge, acting as gatekeeper, is responsible for making a preliminary assessment whether the theory or methodology underlying the proposed testimony is sufficiently reliable to reach the trier of fact. In making the assessment, the court may consider, hang on, whether the science In making that assessment, the court may consider whether the scientific theory or process, one, has been generally accepted in the relevant scientific community, two, has been or can be subjected to testing, three, has been subjected to peer review and publication, four, has an unacceptably high known or potential rate of error, and five, is governed by recognized standards. When applying this standard, judges must be careful not to invade the province of the jury. Critically, it is the qualifications and methodology of the expert, not their conclusions, which the judge is tasked with evaluating. Differences of opinion present issues of credibility, which are properly reserved for the jury. Once the expert's qualifications were established, and assuming the expert's testimony met the standard of Commonwealth v. Lanigan, the issue of credibility was for a jury, not the judge. Accordingly, expert witness testimony should not be deemed unreliable simply because there is a disagreement of opinion or in the level of confidence among the experts, or because the judge disagrees with the expert's opinion or finds the testimony unpersuasive. Such disagreements make up the battle of the experts. Excuse me. This is getting ridiculous, y'all. Dang. 1. Richard Green's education, training, experience, and familiarity with digital forensics qualify him as an expert on the topic. As to the crucial inquiry of the Daubert-Lanigan standard, the proffered expert's qualifications, Mr. Green clearly satisfies the requirements of the standard. Mr. Green has more than 25 years of experience as a computer forensics technician and more than 18 years of experience conducting electronic data analysis and investigations. Mr. Green has been accepted as a digital forensics expert approximately 24 times in the United States. Mr. Green has qualified and testified Mr. Green was qualified and testified as an expert for the first time in 1996 after spending approximately a decade working in computer information technology and networking, building a line of computers and doing computer repairs. In 2006, Mr. Green started a digital investigation firm called United States Forensics, which he still owns and operates today. His company handles between approximately 100 and 120 cases per year and receives annual inquiries for about 3 times as many cases. His company has worked on civil and criminal cases across the country, in both state and federal court, and on behalf of both defense teams and law enforcement. Since starting United States Forensics nearly 2 decades ago, Mr. Green has worked full-time in digital forensics. In addition to being the company's president and founder, he performs the majority of the investigations. He specializes in computer, cell phones, cloud, audio, video, metadata, media, surveillance systems, and other similar systems. Mr. Green has sufficient education, training, and experience in the field of digital forensics. Sorry, guys. He holds an associate's degree in digital forensics and computer investigations. He is a certified computer examiner with the International Association of Criminal Investigation Specialists, and he also holds computer-related crimes investigator, cybersecurity, and computer forensics first responder certifications. I didn't know you could be a computer forensics first responder. That's cool. He is also a member of 4 professional associations in the field of digital forensics and was the keynote speaker on electronic data forensics at the National Association. Stop it, Debbie. He was the keynote speaker on electronic data forensics at the National Association of Legal Investigators 2008 Midwinter Conference. Over the last 18 years of full time work in digital forensics, Mr. Green has received daily on the job training. Namely, in addition to work he does every day at his company. Oh, wow, 5 hours. Namely, in addition to work he does every day at his company, he has participated in listservs, conducted research into the newest developments in digital forensics, and attended training seminars approximately once per week. In total, he has participated in hundreds of training events offered by software companies who provide the digital forensic tools used by the experts in this case, including Celebrite, Magnetic Forensics, and Belkosoft. Mr. Green has attended 67 of these trainings, not inclusive of many of the web training sources that Mr. Green follows on a continual basis since 2022. Mr. Green has attended trainings hosted by Celebrite and Magnet Forensics every year for the last 3 consecutive years and by Belkosoff in both of the last 2 years. His affidavit accompanying this opposition affirms his broad and deep qualifications. On December 31st, 2024, despite Mr. Green's robust digital forensics credentials and experience, the Commonwealth moved to exclude the proposed testimony of Mr. Green as to the 2:27:40 a.m. search artifact. The Commonwealth's motion should be denied. The education, training, and experience described by Mr. Green is not only overwhelming in its own right, but also much more significant than that of the proffered prosecution expert Ian Whiffen. According to his own trial testimony, Mr. Whiffen has testified in the United States only once in his entire career in Michigan. Mr. Whiffen also admitted at trial that unlike Mr. Green, he has no specific certifications in digital forensics, other than a higher national certificate in computing, and does not have a degree in digital forensics or otherwise. By proffering Mr. Whiffen as an expert witness, the Commonwealth has tacitly affirmed, tacitly, if you're Brooks, Daryl Brooks, tacitly, tacitly affirmed that its belief that Mr. Whiffen is qualified. Oh, really? Well, cool. I definitely need to watch that. Because remember, we were saying we wanted to hear what Rob said about that. So I definitely need to go back and watch that. Accordingly, the Commonwealth's arguments regarding Mr. Green's qualifications should be rejected. Contrary to the Commonwealth's contention in their motion, Mr. Green was not broad and vague during the cross examination. In fact, Mr. Green answered clearly and completely the only question the Commonwealth asked him about his training experience and certifications. Out of the 5 digital forensic tools Mr. Green used to evaluate the data from Jennifer McCabe iPhone 11, Attorney Lally chose one, Celebrate, and asked Mr. Green if he had a certification for that particular platform. Mr. Green stated clearly, after seeking clarification of the question, that he had no such certification. He added that his certifications are much broader, as they concern digital forensic fundamentals, how to conduct investigations, and which tools to use. His answers were specific and appropriately detailed. The Commonwealth statement is thus incorrect. Curiously, according to the Commonwealth's own argument by omission, in this motion, Mr. Green remains qualified. and his methodology is reliable in the several other areas of data forensics he testified about in the first trial. The Commonwealth challenges none of those several areas of digital forensics, namely the call logs deleted from Jennifer McCabe's phone, the screenshot of the contact for Uncle Brian A. deleted from Jennifer McCabe's phone, the location data from Jennifer McCabe's phone, the health data from Jennifer McCabe's phone, the location data from John O'Keefe's phone, and the health data from John O'Keefe's phone. That the Commonwealth does not challenge Mr. Green's qualifications as to these topics is further evidence of his eminent qualifications. Such a challenge would fail, as should this one. Let's see what page we're on. Man, this thing's long. 2. Richard Green's methodology is reliable. The Commonwealth's papers fail to identify a methodology for Mr. Green, let alone state why his methodology is flawed. And in fact, the Commonwealth cannot make such a statement because Mr. Green not only employed the same methodology as the Commonwealth's proffered experts, but expanded upon that methodology by utilizing more tools, performing additional low level analysis, and examining overall user activity. The validity of Mr. Green's methodology is evidenced by the fact that all experts employed it and acknowledged at some point during the first trial that the artifact containing the 2:27:40 a.m. timestamp existed and appeared in a deleted state. They all said that. I remember that. They all said that. They just disagreed. I don't understand how something that you text at 6 something in the morning can show that it was deleted at 2 something. That makes no sense to me. I don't understand that. So the 2:27 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a delete record. In the instant of the Google search, Haas Long to Die Cold that was recovered with a timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Nonetheless, the Commonwealth now asserts that Mr. Green's methodology is somehow unreliable. It provides no competent evidence to support this contention. What little support it provides for its Latin. I don't know what it means. I don't know how to say it. Ipsy Dixit assertion on issues for the jury and not a Daubert Lanigan inquiry misconstrues the evidence. The Commonwealth claims that Mr. Green admitted that his misinterpretations of data caused Celebrite to update its physical analyzer program to remove the artifact containing the 2:27:40 a.m. timestamp. But a proper reading of Mr. Green's June 21st testimony transcript makes clear that the question was poorly stated to the point of incomprehension. Yeah, Lally does that. In his answer, Mr. Green was making the point that as of June 21st, 2024, Celebrite had two contradictory versions of physical analyzer on the market. And one version, Insight's physical analyzer, the 2:27:40 a.m. search artifact had been removed, while another version, Physical Analyzer 7, still showed the artifact and in a deleted state. Beyond that, Mr. Green was simply stating his awareness that Celebrite made changes to its software sometime after his viewing of the 2:27:40 a.m. search artifact before trial on the only version of Physical Analyzer available to him at the time. This reported evidence of supposed unreliable methodology is not about methodology at all. It is about two Celebrite programs out on the market at the same time that are presenting differently about the 2:27:40 a.m. search artifact. That is a problem caused by Celebrite, not by Mr. Green. Moreover, the problem is for the jury to determine. It is not a Daubert-Lanigan methodology issue. It therefore does not support any basis for exclusion of any portion of Mr. Green's testimony under Daubert-Lanigan. The Commonwealth also claims that Mr. Green's opinions lack any evidentiary support, cannot be made in good faith, constitute baseless claims. First, contrary to these false and baseless assertions, Mr. Green's opinions are backed by significant scientific evidence. A digital investigation techniques, a NIST scientific foundation review, and draw on the very same data contained in the raw image file obtained from Jennifer McCabe's iPhone 11, which all three experts relied upon. Second, if these claims were accurate, the purported lack of evidentiary support the Commonwealth alleges would go to weight and credibility of Mr. Green's opinions, not the threshold question of whether his methodology is reliable. Once the expert's qualifications were established, the issue of credibility was for a jury, not the judge. Likewise, the Commonwealth claims that Mr. Whiffen performed a comprehensive study of the forensic data and that there is no evidence whatsoever on this device of a search conducted prior to 6:23 a.m. or of deletions. These claims are false. First, Mr. Whiffen did not perform a comprehensive study because he only looked at limited data, only used two tools, and relied nearly entirely on one, his company's tool. His analysis is certainly less comprehensive than that of Mr. Green, who used five tools. Second, there is evidence in the raw data from the device of the 2:27:40 a.m. search artifact and of deletions. This evidence was found in all five of the forensic tools used by Mr. Green, and the most up-to-date version of Axiom continues to show the 2:27:40 a.m. search artifact in a deleted state. Notably, Mr. Whiffen qualifies his statement to the contrary with, of the data I examined. Mr. Whiffen does not mention, let alone account for, the several anomalies Mr. Green discusses in his affidavit, accompanying this opposition that undercut the entire December 2024 report of Mr. Whiffen. Nor does Ms. Hyde. In any event, these claims by Mr. Whiffen are no more reiterations of his opinions and thus clearly are not a Daubert-Lanigan matter, but are cross-examined in jury matters. The Commonwealth's claim, Maiko, hey dude! The Commonwealth's claim that Ms. Hyde conducted an encompassing review is similarly false. That's a citation. In fact, most recently, Ms. Hyde did exactly the opposite, contravening her own first trial testimony about the importance of using multiple tools. She produced a new report in December 2024, relying only on the updated Celebrite physical analyzer. Unbelievable. These phrases and claims used by the Commonwealth in its motion are not just incorrect, they further demonstrate a fundamental misunderstanding of Daubert-Lanigan's two core concerns: the province of the judge in a Daubert-Lanigan context, and the province of cross-examinations and the jury. These are not the only errors the Commonwealth makes in its motion. For instance, the first footnote of the Commonwealth's paper is incorrect. Celebrite is not the leading forensic data extraction software tool. Celebrite is a company, one of the companies that provides one of the digital forensic tools relevant in this case. It is clear that the Commonwealth's myopic focus on Celebrite physical analyzer is misleading, and allows the prosecution to disappear the 2027 40 a.m. search artifact. Who wrote this motion? And I'm loving it. I am loving it. I am here for it, man. The Commonwealth is trying to disappear that search. Despite Jessica Hyde's testimony during the first trial about the absolute pertinence and value of using multiple tools, the Commonwealth seeks to discredit Mr. Green, who did exactly that, while proffering experts to rely almost exclusively on Cellebrite Physical Analyzer to perform their analysis. This contradiction sheds light on the undeniable effect of the Commonwealth's motion. Now discuss only data forensic tool, Cellebrite Physical Analyzer. Manipulate all Cellebrite Physical Analyzer programs through some black block process in the electronic backroom of Cellebrite so they no longer show the artifact containing the 2:27:40 a.m. timestamp and euphemistically labeled the mysterious and suspicious process and update. Then claim Mr. Green is unqualified and his methodology is unreliable simply because he will not play along with the manipulations of the Cellebrite Physical Analyzer program, especially in the light of the Axiom program previously used by Commonwealth witnesses Garino and Hyde, still showing the artifact containing the 2:27:40 a.m. timestamp and in a deleted state. In addition to the prosecution's newly contrived debunked narrative being false, the debunked parlance in a Daubert-Lanigan motion is inappropriate and can be seen as an improper attempt to garner media headlines and otherwise prejudice future jury pools. Mr. Green's methodology is generally accepted in the relevant scientific community, such that this court needs to reach the 5 non-exclusive Daubert-Lanigan factors. Well, he is absolutely 100% correct. Daubert-Lanigan hearings are because the expert witness is not actually an expert and they're trying to slip them in. It's to see if they are qualified to testify, not if what they're testifying to is credible. That's for the jury to decide. That's for the jury to decide. That's not why you exclude an expert. You exclude an expert because they're not really an expert. So you do the Daubert hearing where you ask them questions about their expertise. That's what a Daubert hearing is for. We already know this guy's an expert. We've been through this once already. Brennan doesn't want him in because he doesn't like his testimony, not because he's not an expert. Oh my God. This is ridiculous. And they've even tampered with Cellebrite. They have tampered with Cellebrite to try to get rid of this any trace. And now Jessica Hyde, who said in her testimony that it's good to use more than one program, is now only using the one program that they updated that now does not show the timestamp for the text message. I mean, for the search. I don't know why I keep saying text. For the search. My flabbers are gasted. What? I didn't think this could get any shadier, y'all. I really didn't think this could get any shadier than it already is. I can't believe I'm surprised at this because I really didn't think it could get any shadier. I really didn't. Mr. Green's methodology is generally accepted in the relevant scientific community such that this court needs not reach the 5 non-exclusive Daubert-Lanigan factors. Mr. Green's methodology was employed by the Commonwealth experts in this case, and it is supported by relevant digital forensics literature on best practices from the National Institute of Standards and Technology, a NIST Scientific Foundation review. As a result, Mr. Green's methodology is properly regarded as generally accepted in the relevant scientific community. Under Commonwealth v. Davis, this general acceptance by the relevant scientific community is sufficient. Therefore, pursuant to Davis, this court need not reach the 5 non-exclusive Daubert-Lanigan factors. This issue of the 22740 AM search artifact should reach the jury. Even if this court reaches the 5 non-exclusive Daubert-Lanigan factors, Mr. Green satisfies them, because general acceptance of Mr. Green's methodology by the relevant scientific community is sufficiently well established. This court need not reach the Daubert-Lanigan factors. However, even if the court reaches those 5 non-exclusive factors, Mr. Green's methodology satisfies Daubert-Lanigan precepts. Again, as to the first factor, Mr. Green's methodology is generally accepted in the relevant scientific, i.e., data forensics community, and indeed by the Commonwealth's proffered data forensics experts themselves. As to the second factor, the methodology and the tools used are regularly subject to testing, both by the experts who use them and the companies who provide them. This regular testing is made apparent by the many legitimate updates and improvements made to the tools by their respective companies, which result in the periodic release of new versions of these tools. Third, while the methods used in digital forensic investigations are often not peer reviewed in a formal process, trustworthiness is established by members of the digital forensic community trying out proposed methods, testing, and circulating updates within the community. Because this testing of digital forensic tools takes the place of peer review in the digital forensic fields, it is therefore sufficient for purposes of a Daubert-Lanigan analysis, which must be flexible and which may require judges to apply differing evaluative criteria for different methodologies. Fourth, the methodology also does not have an unacceptably high known or potential error rate. The Commonwealth's own proffered experts endorse and employ this methodology as scientifically sound, reliable, and accurate. Finally, the methodology is governed by recognized standards. Nonetheless, all the proffered data forensic experts in this case are using the same methodology and in various instances at various times using the same or similar data forensic tools. In all events, the Daubert-Lanigan factors are non-exclusive, so no factor is dispositive. Not all of the factors identified in Daubert will be applicable in every case. A trial judge accordingly has broad discretion to determine how to access the reliability of expert testimony. Because Mr. Green is qualified and his methodology is reliable, the court must deny the Commonwealth's motion. Jeez, he's not done yet. 3 more pages. Good Lord. I'm not going to read the affidavit because I didn't realize this was this long. But I'm glad I read it before I watched the hearing, because now, before I was like, oh, they're just trying to mess up the defense case. But now I'm like, I'm fired up because they're playing dirty and I'm mad. 2. The Commonwealth has not shown that an evidentiary hearing is required. Daubert Lanigan evidentiary hearings are canceled in Massachusetts once papers in opposition to the request for such hearings are filed, demonstrating the lack of a need for the hearing. Affirming judge's decision made on the basis of the parties' papers and arguments not to hold an evidentiary excuse me. Affirming judge's decision made on the basis of the parties' papers and arguments not to hold an evidentiary hearing and to admit the expert's testimony. This is another case that fits under that proposition. The core concern of the Daubert Lanigan standard is promoting reliability by ensuring an expert has sufficient qualification and employs a reliable methodology. This opposition establishes Mr. Green's eminent qualifications on the subject matter in dispute and the reliability of his methodology. The Commonwealth's bare and conclusory assertions to the contrary are insufficient to warrant an evidentiary hearing on the issue of the artifact containing the 2:27:40 a.m. timestamp. The Commonwealth's motion appears to stem not from a genuine dispute over Mr. Green's qualifications and methodology, but from its transparent and disquieting campaign to deny Miss Reed the ability to present her own defense through her own qualified and reliable witnesses. Didn't I just say that? I just said that. To prevent the ultimate jury from receiving and evaluating evidence that is harmful to and inconsistent with the Commonwealth's theory of the case, and to drain Miss Reed of her resource in advance of trial in the process by submitting conclusory and insufficient motions under the guise of Daubert Lanigan. The Commonwealth seeks to force the defense to repeatedly participate in unnecessary motions and attendant resource intensive mini trials, therefore needlessly expanding limited defense resource and diverting them from trial preparation. Through this misuse of Daubert Lanigan, the Commonwealth also effectively is obtaining depositions of defense expert witnesses, including the attempted locking in under oath of their testimony for use at trial. This instant motion and others like it are tantamount to legal tyranny, not a search for truth and justice. Allowing the Commonwealth's motion to exclude Mr. Green would not only sanction this misguided and disturbing approach, but also the impermissible and intolerable adverse jurisprudential consequences of the Commonwealth's actions, which would extend beyond the instant case. Allowing the Commonwealth's motion would set a precedent that when the Commonwealth does not like a proffered expert's opinion, it may file rote, vague, legally insufficient, and vexatious Daubert Lanigan motions to exclude that proffered expert and, more important, the evidence associated with the expert. That is, the Commonwealth will make Orwellian unpersons of the evidence, which is problematic for its theory. The danger of this approach by the Commonwealth and the precedent it would set cannot be overstated and respectfully should not be countenanced by this court. For these reasons, the Commonwealth's motion, along with its included request for an evidentiary hearing, must be denied. Conclusion. For the above reasons, Ms. Reed respectfully requests that this honorable court deny the Commonwealth's motion to exclude certain testimony of defense witness Richard Green and its included request for an evidentiary hearing. Respectfully submitted for the defendant Karen Reed by her attorneys Robert J. Alessi. Yes! Oh, Yannetti signed it too. Who did Jackson sign it too? Yes. Who wrote it? Did Alessi write it? Alessi's amazing. That was the most amazing motion I've ever read. I loved it. I loved it. That was great. Now, there was another motion. The motion to exclude was good too. I've got it somewhere, but I didn't pull it up to read. I am My voice is gone. I'm read out. I'm not going to read the affidavit. It probably is just more of the same, but it's from Mr. Green. But let's go ahead and I've got the hearing pulled up, and this is when I have to turn off my camera. That was that was a really good motion. Yeah, this is it's kind of like the affidavit. It's oh yeah. It's kind of like a CV basically. Oh, yeah, it's boring. It's a list of yeah, it's like a CV basically. Yeah, you don't need to read that. We don't need to read that. But yeah, that was a good one. I love all the Orwellian comments. That was good. That was really good. Should I turn my camera off or should I risk it? I don't know. If it crashes, I will turn my camera off. No, I did not tell you to go to drunk Florida woman, and I think that's a law and crime thing. They will. Don't need to watch people milling around the courtroom.
We may not be there. Oh, thank you.
Laura, do we have a copy of Jessica's report that we admitted as exhibits in the file, just in case you want to separately? Thank you.
Another thing I like about Alessi is that he knows how to suck up without sounding like a suck up. You know what I mean? Like he knows how to be respectful without I don't know how to explain it. Like he knows how to defer to the judge without sounding like he's being a brown noser, I guess is okay, so that means I need to turn my camera off. Thursday, you guys. Thursday I have new internet.
Hear. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, Unified County of Norfolk. You are near, give your attendance, and shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge, this is 22-117, the Commonwealth versus Karen Reed.
Honorable my butt. But that's just my opinion. Sally.
Good morning, Your Honor. Hank Brennan for.
Good morning, Mr. Jackson.
Good morning, Your Honor. Robert Alessi.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Oh. Good morning, Mr. Birchie. Okay, let's see. So we've got several matters for this morning that I want to discuss. So first, there's filed a motion to recover expert-related expenses from the Commonwealth, and we'll discuss that in some manner at the end of the hearing today on Ms. Voss's opposition to the notes. And then there's the Commonwealth's motion for reciprocal discovery pertaining to the employees of ARCA. And the last one is the Commonwealth's motion to exclude witness Richard Green's debunked opinions. So those are really in that order, except I think we should start with the non-party Gretchen Voss's motion to reconsider regarding the notes. And I do want to say that I received this morning a motion to file an amicus memo. The signatory is Mr. Albano. I've received that. I will allow that to be filed, and I've read the motion and the memorandum. So I will hear you, Mr. Birchie.
Good morning, Your Honor. Rob Birchie for Gretchen Voss. I'd like to start by just thanking the court for taking the time and giving me the opportunity to revisit the court's ruling of December 5. That ruling allowed in full the Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages, and voicemails in the possession of Gretchen Voss or Metro Court. Ms. Voss and Metro Court complied with the court's order for production of documents on January 2nd by producing to the court all of the responsive materials, the unredacted tapes, and the text messages that involved on the record communications by Voss.
Oh, come on.
With defendant Reed. I'm here today to implore the court to reconsider that part of its ruling, but also would require Gretchen Voss to turn over handwritten notes of an interview with Reed that the parties had agreed in advance would be off the record. What's in those notes is really a black box. The Commonwealth has provided no information indicating what it believes the notes will reveal, or why it has
You are unmuted.
particular reason to delve into them. So the question before the court is whether the Commonwealth should be entitled to forage through this reporter's notes and compel her to break her promise of confidentiality with the source in the ungrounded hope of finding relevant and material evidence somewhere in those notes that will aid in a prosecution of the defendants. The stakes for Gretchen Voss are considerable. As she set out in her second affidavit submitted to the court with our motion for reconsideration, her effectiveness as an investigative reporter depends upon her having the ability to use the tools of the journalism trade. And among them is the opportunity to reliably assure her sources that certain information they provide to the reporter will be off the record. The precedential stakes are high as well, because the Commonwealth is essentially asking the court to give no weight whatsoever to the off the record nature of the notes. and that reality illusory. Off the record is a phrase you hear in virtually every conversation between a reporter and the source. Frequently, it's an interjection in the course of a sentence. This is off the record. The kind of lubricant that allows a source to have a free and full exchange with the reporter without having to guard every word they speak. And receiving information off the record is often a technique by a reporter to establish trust and rapport with a source. That source might be a whistleblower, might be a frightened migrant, or might, like Reed, be a criminal suspect. Considerations, quote, are essential in building trust between journalists and their sources, allowing for candid discussions that can provide context or background without the risk of public disclosure. The result, it says, is to enhance the depth of the reporting and provide leads for other sources. In Ms. Voss's case, she states in her second affidavit, which we filed with motion for reconsideration, at paragraph 11, she says, obtaining information from sources off the record is a normal and critical part of my work. Like most investigative reporters, I frequently agree with sources, including named sources, to keep certain of their statements or interviews off the record, not to be published anywhere. Keeping my word on this is critical to maintaining credibility and trust, and thus maintain source relationships while not interfering with the flow of important information to the public. The court's December 5 order forces Gretchen Voss to choose between either keeping her word to her source and thereby violating the court's command, or else obeying the court's order and establishing herself as a reporter whose word cannot be trusted. It's an unnecessary choice to present to her, at least on the facts of this case. The court shouldn't insist on publication of the off-the-record notes because the Commonwealth has failed to meet its burden under Rule 17 to show that mandated production of the records on the facts of this case would not be unreasonable or oppressive. And also because requiring Voss to turn over these confidential notes would damage First Amendment interests more than it would benefit the public in achieving justice for this criminal defendant. Now, I keep saying on these facts, because it's very clear that the inquiry is a fact-sensitive one. The First Circuit wrote in the Bruno and Stillman case that under Massachusetts law, the task is one that demands sensitivity, invites flexibility, and defies formula. While obviously the discretion of the trial judge has wide scope, it is a discretion informed by an awareness of First Amendment values and the precedential effect which decision in any one case would be likely to have. And in Ray Cusimano in 1998, the First Circuit said, that was a case like this one, with that involved a demand for confidence to enforce the fact-specific nature of the inquiry. In Cusimano, they said, when a subpoena seeks divulgement of confidential information compiled by a journalist in anticipation of publication, courts must apply a balancing test. This test contemplates consideration of a myriad of factors, often uniquely drawn out from the factual circumstances of the particular case. Now, as I noted, in the December 5 order, the court drew no distinction between the on-the-record and off-the-record interviews. When it applied the Massachusetts balancing test for mandating production of reporters' notes, texts, and audio texts, audio recordings, it did not treat this confidentiality promise as a factor in the equation. That, we submitted, was critical oversight, because whether you call it a privilege or not under Massachusetts law, Massachusetts does recognize that there is some degree of deference to be given to a promise of confidentiality. In Bruno and Stillman, the court said courts faced with enforcing requests for the discovery of materials, note it says materials, not source identities, and courts faced with enforcing requests for the discovery of materials used in the preparation of journalistic reports should be aware of the possibility that the unlimited or unthinking allowance of such requests will impinge upon First Amendment rights. In determining what, if any, limits should accordingly be placed upon the granting of such requests, courts must balance the potential harm to the free flow of information that might result against the asserted need for the requested information. So what are the factors that the court should look at when conducting an analysis under Rule 17 and under the balancing test? Taking Rule 17 first, set out in the LaRouche case, they say the Nixon case, where the Supreme Court ruled that in order to require production prior to trial, the moving party has to show, number one, that the documents are evidentiary and relevant, number two, that they're not otherwise procurable reasonably in advance of trial by the exercise of due diligence, number three, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial. And number four, that the application is made in good faith and, critically, is not intended as a general fishing expedition. In short, the court was explaining that the special prosecutor in Nixon was required to clear three hurdles: relevancy, admissibility, and specificity. And the court held in Nixon that there was a sufficient likelihood that the tapes contained conversations relevant to the offenses charged, and sufficient preliminary showing that the subpoenaed tapes contained admissible evidence. In this case, however, there's been no showing that the handwritten notes contain information relevant to the offenses charged, and no showing that the handwritten notes contain admissible evidence. When you apply it to the facts of this case, there is uncertain relevancy of the information in the off-the-record notes. Not seeing them, it's hard to know whether they're relevant or not. But there's no specificity whatsoever in the form of a preliminary showing by the Commonwealth that the notes contain admissible evidence. Compare that to the materials the court ordered disclosed. The court found that there were indications in the redacted audio tapes that when unredacted, the tapes would contain relevant and admissible evidence. That's on page 5 of the court's order, which says the Rule 17 standard is satisfied, not only based on the tapes. But there's no examination whatsoever of whether the interview notes would be anything more than a fishing expedition. To the contrary, the fact that nothing from that interview that resulted in the handwritten notes, nothing from that interview was used in the story. And that would suggest that the interview did not contain significant relevant information. As to the balancing test and the First Amendment interests, here too, the December 5 order ignores the on-the-record, off-the-record distinction. That distinction matters. Confidential information is extra protection because, as stated in LaRouche, disclosure of such confidential material would clearly jeopardize the ability of journalists and the media to gather information, and therefore would have a chilling effect on speech. The court in LaRouche identified First Amendment interests that militate against disclosure of confidential information. One was the threat of judicial intrusion into the news gathering process. Another was the disadvantage of a journalist appearing to be a research tool for the government. Number 3 was the resulting disincentive to keep outtapes, or in our case, keep notes. And number 4, the burden on journalists' time and records and resources in responding to subpoenas. And if you look, Your Honor, at the affidavit of Chris Vogel that was submitted with our original opposition, he talks about each of those factors in his affidavit from paragraphs 13 through 18. He says he worries that compelled disclosure may lead to a public perception that Mrs. Voss is taking sides in this case or is acting as an investigative arm for the judiciary. Trust in the news media is already fragile because reporters compile information for a living. They will always always be attractive targets of discovery for one side or the other. The unrestrained use of subpoenas to compel testimony or documents from reporters will create or reinforce the impression that objective journalists are working as agents of the government or the defense. The fourth estate can only serve its role as a pillar of democracy if it has the public's trust. Second concern that editor Chris Vogel pointed out is that in his affidavit is that another risk of compelled disclosure is that if it becomes easy or routine to subpoena journalists to hand over their interview notes, the legal and administrative costs of battling or complying will chip away at the precarious resources of much of the media. A third factor that was concerning him was that easy allowance of media subpoenas also risks leading to a decline in investigative journalism altogether. This is the most expensive kind of journalism. Reporting, writing, editing, and fact-checking investigative pieces take significant time and resources. Magazines like Boston Magazine will not be able to risk becoming enmeshed in situations such as this one, with the result that they shy away from controversial topics and the flow of vigorous reporting will suffer. We'll feel we have no choice but to select tamer, less controversial topics for our coverage. Another concern expressed by Editor Vogel is that reporters will be incentivized to destroy notes and interview tapes after a story is published, and that could harm the news outlet if it later needs to follow up on that piece. A fifth consequence is that reporters may tend to be circumspect in the way they gather information, in the way they conduct their interviews, and not be so vigorous in their questioning of sources and their documenting of interview notes, aware as they will be that their work may become the subject of public and judicial oversight. And finally, one factor that separates this case from many other cases out there is that Gretchen Ross has been the subject of invasive vitriol simply for writing about this controversial and very public matter. Public disclosure of her interview notes in this case risks putting her again in the limelight. Now, the court mentioned in its ruling that it appeared that she was no longer in fear of harassment because she had attended every day of the trial. I would submit that that shows that she was dedicated to covering the trial, come what may. She tells me she has, in the recent past, gotten more pushback on social media, including the fact that one commenter on Facebook, who I won't name, posted her personal telephone number for everyone. And the commenter to that post suggested I'll call her right away. And she's received several strange phone calls since that time. Because of the disproportionate harm to First Amendment and Article 16 interests caused by production of the confidential interview notes, we ask this court to consider its December 5 ruling and deny that part of the Commonwealth's motion that seeks those notes.
All right, thank you very much.
Thank you, Your Honor.
I do have one point to make to you, Mr. Birch. In the amicus brief, or the memo that was filed this morning, I just want to be clear that I am not looking for Ms. Voss's own interpretations as well as her likely impressions and thoughts about the interview and overall story to be provided. But it makes sense to me, and I'm going to hear from the Commonwealth, and if you want to respond first, that any information that reflects or relates to conversations with the defendant must be turned over.
I'm not sure what the question is.
So I'm not looking, the amicus brief and your argument suggests that if I order these notes to be provided, and just to be clear, I do appreciate that they were provided to me to review in camera. So I can see a distinction between what I'm being told that generally all notes reflect the author's interpretations as well as her likely impressions and thoughts about the interview and overall story. That's not what I'm considering releasing. But I think in this criminal case, the Commonwealth has proven that any material that reflects or relates to communication with the defendant must be turned over. So what I'm going to propose is that I do believe that there's some material in these notes that I don't need to provide to the Commonwealth, that I don't need to order be provided to the Commonwealth, that are just sort of observations. It's the communication between the defendant that's critical here. So I'm going to give you the opportunity to propose redactions to me. I have the notes, and you can propose redactions to things that are not reflective of communication with the defendant, observations, things of that nature.
Ron, there's nothing in the interview notes that is reflected in the story except architectural details, that there was a rosary on the bureau and the wall was blue, or whatever it might be. And I went through the notes with this question in mind. Can you separate the impressions, integrity of the thoughts of the writer from the statements of the interviewee? And I don't think they're distinguishable. I think they're
Okay.
all melded together in one. And frankly, it's her selection of questions that she asks Ms. Reed that gives an eye hole into what her thoughts are about the case. She shouldn't have to produce that work product. And the Commonwealth hasn't shown that there's any more relevancy to these conversations with Gretchen Voss than there would be with any other conversation that Ms. Reed had with anyone else. There's no reason for the Commonwealth to be going after Gretchen Voss as a reporter for this, other than the fact that she's a reporter and she's done the investigative work already that presumably the Commonwealth has already done.
Okay,
Thank you.
thank you. Commonwealth?
Your Honor, I'll simply say we defer to the court's judgment and whatever limitations the court imposes. I have no further argument.
Okay. All right, so I'll take this under advisement. Thank you. All right, so paper 442. This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ARCA. And I know from when we were last in court, the Commonwealth was perhaps having conversations with the federal people to see if you could get anywhere with this. Is there anything I need to know in that regard? And if we need to do it at sidebar, we can do it at sidebar.
I don't think there's a need, Your Honor.
Okay.
Although it's not incumbent on the Commonwealth to pursue Rule 14 discovery of a party that's going to proffer an expert, Commonwealth made best efforts anyways. I filed a TUI letter, and I was unexpectedly not disappointed when I received a response last night. It's insufficient, it's inadequate. So the issue of pursuing Rule 14 discovery through the proponent of the expert, that being the defense in this case, is something that is a matter we're going to have to address.
Okay.
I did speak to the defense this morning. Since the TUI letter came last night, they have, I don't want to speak for them, but have asked if we would consider some time so they can respond. I am content if it gets deferred until the next date, but it is an argument that needs to be made.
Okay, who's arguing now for the defendant?
Good morning, Your Honor.
Morning.
I agree with Mr. Kennedy's recitation of our conversation this morning. If it pleases the court, last night, reviewed it last night. I think that it'll be incumbent for me to at least analyze that letter in a little bit more detail and utilize that letter in my response to the Rule 14 argument. So if we could have another date. what
Sure.
the
Well,
next
we
date
have
is.
next week, Thursday and Friday scheduled.
That's what I was
So
thinking.
we'll do this next week and come up with proposals on how we can certainly not violate anything that the federal court has said we can't do, but ways that we can go about it.
We'll be mindful.
All right. So if you can work on that, I'd appreciate that.
Sure.
So I will take the lead from the two of you on that.
Thank you.
Okay. All right. So this brings us to,
Wait, what has the federal court said that they can't do? Did I miss something? What is she talking about?
the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions. So I have received a great deal of pleadings on this. So the Commonwealth's motion, and there was a affidavit attached, a report attached from Mr. Whiffen. The defense has filed an opposition, an affidavit from Mr. Green, and then another affidavit from Mr. Green that doesn't, they're two separate affidavits. And the affidavits are clearly different in substance. So I'm a little, I don't know what you want me to think about that, but why don't we hear the Commonwealth on its motion first?
May it please the court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long to die in a cold at 2:27 a.m. And secondly, to exclude an opinion that there was some type of intentional deletion of that entry. This case, I propose on behalf of the Commonwealth, is appropriate for a Lanigan hearing. At that Lanigan hearing, I suggest that Mr. Green should testify and answer questions about his affidavit and his opinion he would like to subject it. In fairness, the government would call an expert as well. If this case, as the court proposed, potentially scheduled for next week, Mr. Whiffen would not be available, but Ms. Hyde would be available, and I would call her as a witness. Mr. Whiffen, if necessary, is available later in the month as a witness. Suggest this is Mr. Green and one witness from the Commonwealth. The Commonwealth witness will be able to explain the science, the data, forensic science, and methodology. And Mr. Green, I suspect, should be in a position to explain his ultimate opinions because what we see in his affidavit is an absence of methodology. Mr. Green has filed 2 affidavits in this case. They are very, very similar, but there are very significant changes to those affidavits.
Oh my God, again with the methodology. This is going to be just like the other thing with Dr. Russell. Methodology, methodology, methodology.
And it stands out as very interesting, the changes to the affidavits when I look at them. On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession.
Semantics.
Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9. He talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as gray key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, insinuations and surmise, and conjecture, and claims that have no factual basis, but there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive
Dangerous?
comments that a user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting, but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened. But when we look through his entire affidavit, we don't see any attachment of raw data. We don't see an updated report. We don't see any.
Who tampered with evidence? Who tampered with evidence? Who tampered with evidence?
Viable information that in any way supports his speculative accusations. And so the defense, without having an opportunity for Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common viewing the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government's going to take to this case. Mr. Green's going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there's some type of race that Mr. Green looked at or used more tools than a Commonwealth expert. Analogy is that of an expert. Anybody can take expert then to interpret the X-ray, the data. In this case, Mr. Green, and it has a number of X-rays, that somehow there's significance to, but what it lacks is a forensic analysis of that information. And it is clear in his affidavit that it lacks that. He cites two opinions. His first opinion is based on Cellbrite processing and Axiom processing. I'm not going to go through all the little details that we dispute or go through a technical assault on each point, although that the overall idea of this evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is stepped aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite, he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbrite after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason. I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance of Cellbright, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the government, the defense house, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs that say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact as follows, that the artifact is in Safari suspended state tabs, and then has the last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, they don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, and this is the death knell, really, for the analogy that the defense tries to make. The Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results from the artifact may contain an earlier date and time compared to the results in the Safari history artifact if multiple devices on one iCloud account. And so by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much clearer than the actual search. And this has been presented to the court, and we've provided the trial transcripts of Ms. Hyde and Mr. Whiffen. When a tab is open, many tabs can be open. It is open at a particular time. And if that tab is reused, the original time will imprint. And so certainly Mr. Green knows of the Commonwealth's argument. He knows of the opinions by Mr. Whiffen and Ms. Hyde because he takes shots at them or makes mention of them in his report. And yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of side. When you look at their reports,
All right, internet. Why are we buffering? Come on.
it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that How Long to Die in the Cold was somehow inputted at 2:27. The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen and Mr. Green. But a simple understanding, wall file can contain information as a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact, he implies that there were 3 searches in his affidavit, number 16. Just look at this phone that there were 2. Surprised that his second opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because, number one, it doesn't have any resonance. Anything somewhere, somehow. Not an uncommon. The claim, or the opinion number 2, the defense would like the jury to hear, is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit to the court, and in an advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number 2, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with the PDF being modified. Wow. An extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number 1 are so scientifically and forensically unsound. This is a tactic to confuse the issue. And think about the import of this baseless claim by Mr. Green. It is suggesting that a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when you don't have any facts. Now, how could one cause manipulation? There is scientific ways that could be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact and data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search and not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation because it didn't happen, he turns to police manipulation. And he says that there can be a problem where the hashes don't match, but the problem is the hashes do, they match. He complains that he did not receive the PDF when he received the download.
Jen McCabe may not have manipulated her phone, but she's manipulative. I'll give you that for sure. Just, I can tell by her demeanor on the stand that she's manipulative. She manipulated something. I guarantee you she manipulated something.
And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, gray key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. Commonwealth's expert witnesses went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless, inaccurate, and prejudicial claims. The Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, expert. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two, the opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffin's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no testing that his opinions have been subjected to. There is no peer review. There is no other alternative support for his opinions. They're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. It has an unacceptably high known or potential rate of error. Well, if we see and read Ms. Hyde and it's just a high level of error, it's gross error, it's total error, it's wrong, and is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom. or the guidance that they give him, he sidesteps both of them to give the opinion he wants to advocate for the defense. At every turn, the positions of Mr. Green are not only unsupported, they're unverified. And so what arises from this subterfuge is that Mr. Green is really just a vessel, or an attempted vessel for the defense, third-party public defense. It is not lost on me, I'm not unmindful of the data on the phone being a search how long Diane Cole that occurred after 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time, Mr. O'Keefe, and how long he could survive the cold. Under the extraordinary broadness of circumstances in the depth of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance, that there is a inquiry, something forming in the mind of the accused is then shared with the witness, Ms. McCabe, and in response, she makes the search, which is entirely supported by all the credible forensic evidence. If Mr. Green is going to be witness in front of the jury in light of the fact that he has no methodology and he's wrong on the science, in addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense, he should have to stand behind those claims under oath. And so I'm asking for a landing and hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Lessing?
May it please the court. Mr. Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search house long to die in the cold that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat obviously and presided over that trial. Your Honor did not issue after his testimony any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution after his testimony stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established again without objection. And
Somebody has a cell phone in court?
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that There's no challenge to 5 other areas of data forensics. And there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs. And I would like to, Your Honor, use those in a moment. The Commonwealth that Mr. Green does not articulate a methodology.
He counted them.
That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with a methodology. And here is the key, Your Honor. While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a fact, there are 2 reports. Neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, Jen McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step 1 in the methodology that everybody agrees to, everybody agrees that occurred. Number 2, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Cellebrite UFED, a tool of Cellebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says As soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is
Whoa, glitch. What is happening?
value, and that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffin's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim. This value is talking.
What in the world? Stop glitching.
Here's the key point. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all.
Oh, so that's not on my end? That's on Law and Crime's end? Okay, good. I was thinking it was my internet. Because you know how embarrassed I get when my internet acts up.
A fancy camouflage way of saying, Mr. Whiffen saying, I can't validate this hash value because of the way Trooper Guarino processed it. Do it, Mr. Guarino, Trooper Guarino, the right way when he got it. And why is this of concern? Add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Guarino used the Celebrate UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for the data. Then what happens, misstep number 2, Trooper Guarino only provides a PDF of the hash value. He used gray key, which was a mistake, because gray key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person, and the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, with all the concerns now about the data and deletion for it, and it wasn't caused by the defense, it was caused by Trooper Guarino, who didn't do this properly. And with regard to the methodology, I want to go back to Exhibit 1. So, importantly, Your Honor, 1 through.
Oh, the shock and horror. Horror, I tell you, horror. Shock and horror.
4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffen, Ms. Hyde, and Mr. Bean all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. And 4, the methodology, you then process the data with a appropriate tools. Nobody disputes that Celebrite Physical Analyzer and Magnet Forensic Axiom are two of the many tools that are available to use. There's a dotted line that I've put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5. And 1 through 4 is usually all one needs to do as a data forensic examiner. But Mr. Green went on to do more. Number 5, further processing of data as warranted, and he explains why it's warranted here with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap, Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So, interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Celebrite Physical Analyzer and his own software, ArtX. That's it. What I'd like to, Your Honor, is ask if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Okay.
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used, and how insufficient Mr. Whiffen and Mr. Garino are. So if you look at the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of her tools, exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Celebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important and I think remarkable in this chart. Mr. Green did comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not an issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Daubert Lanigan hearing. Opinions are not. Here's what Mr. Whiffen had to say about the issue. This is Exhibit 2 to our opposition. It's the June 17, 2024 testimony of Mr. Whiffen, page 1-10, starting on lines.
Now it's me. I'm buffering again. Sorry, guys. Thursday, all this will be over.
The question. And what, if anything, did you find with regard to the web history artifacts? Answer. This is Mr. Whiffen. So the 22740 timestamp was correct insofar as that is the time that is shown within the database. It was indeed a deleted record. But the interesting thing was why the timestamp said 22740. And I did some testing on this and discovered the reason why 22740 was actually listed in the database, even though that's not the time. Here's the key, in my opinion, that the search was conducted. So Mr. Green's opinion is, after applying the methodology that everybody agrees to, after using the same tools as every other witness for the Commonwealth used plus more, Mr. Green's opinion is, to a reasonable degree of scientific certainty, that that search and that record that everybody saw at the time of trial at 22740, House Loan to Die in the Cold, Mr. Green says it means what it says. The search occurred at that time. Now, the Commonwealth, in its recent reports, and they did this also at trial, they said, yeah, we see it, it's in there. Ms. Hyde said, I see it. It's not only in there in Celebrite Physical Analyzer. I used Axiom, just like Mr. Reed. Mr. Whiffen didn't use Axiom. Ms. Hyde said, and I'm going to point to it specifically, Axiom shows it as a 220, that search is a 224. In fairness to trying to get the best decision for Your Honor here, they disagreed, Mr. Whiffen and Ms. Hyde, as to whether that meant the search actually occurred at 22740. That's the opinion that's disputed. So in fairness to the issue and accuracy, those witnesses diverted at the end as to whether what that timestamp showed, 22740 a.m., did the search really occur then, or as the Commonwealth said, did it occur at 6:23 in the morning? Mr. Whiffen says it's a difference of opinion because he says it's my opinion. The Commonwealth in this motion tries to make it seem like it's an issue of fact, and that Mr. Green doesn't have any facts. Well, Mr. Green's got a lot of facts, and he also, of course, has an opinion. So what we have from these two demonstrative exhibits, Your Honor, is a statement of the methodology in Exhibit 1 that every witness agrees to. Not only is it Mr. Green put a methodology, but we prove up in the opposition that there's no dispute. What's interesting, Your Honor, and I think quite remarkable, is that neither Mr. Whiffen in his 40-plus page report of December 24, nor Ms. Hyde in her December 24 4-page report, neither one of them say Mr. Green's doesn't have a methodology. They don't say we dispute his methodology. It's the Commonwealth's attorneys that are making that dispute. And that is not appropriate. It's got to be your expert And I think there's a reason why the experts of the Commonwealth are not talking about methodologies or saying there's a dispute, because it's objectively verifiable that there's not a dispute over the methodology. What is also important is what has happened since the trial. And what I want to do is give a baseline of the trial, because I think it underscores the two issues that Your Honor have in front of you: qualifications and methodology. And the qualifications, all I'm going to say about that is Mr. Green has 25 years experience in computer forensics, and he has 18 years in digital forensics. And the 18 is only because digital forensics became a thing 18 years old. There can be no dispute, and I think that's why the Commonwealth didn't really say anything about it, is because if you lay down Mr. Green's experience next to Mr. Whiffen, Mr. Green testified 23 times as a qualified digital forensic expert in 7 different states. Mr. Whiffen, he's testified in 2 states, one of which was here, and he does not have anywhere near the years of experience. Here's another very important point: certifications. Mr. Green lists 3 certifications. He lists an enormous amount of constant updating. And I just want to state a point about digital forensic experts. They're not like medical doctors where you see people with PhDs, etc. These are folks that keep updated because the computers change so much. So that's why you see such a great listing of Mr. Green in terms of his training and certificates, etc. However, if you compare Mr. Whiffen's qualifications to Mr. Green, and I'm again going to use Mr. Whiffen's own words with regard to his qualifications on his June 7th, this is again Exhibit 2 to our opposition, his June 17th trial testimony, page 1-6. Question, and this is a question from Mr. Lau. Now, with regard to your education in this area, what, if any, certifications do you have? Answer, no specific certifications. I've done the Celebrite coursework since joining Celebrite, but other than the 2, 3-week course in Ottawa, and then again the 2-week course in Ottawa, those are police training things when he's a policeman. I don't have the SANS training or any of that kind of training certifications. Now, I am not here today to challenge Mr. Whiffen's qualifications, but how could it possibly be asserted that Mr. Green's not qualified if these are the qualifications of Mr. Whiffen? With regard to what has changed since the first trial, and I think this is incredibly important with regard to the methodology inquiry of Your Honor. I went through on Exhibit 1 the methodology that everybody agrees to, but the court doesn't have to take my word for it on this demonstrative exhibit, because Ms. Hyde gives the best explication of the methodology that Mr. Green used, because she used the same one before trial and at trial, but she's now narrowed it for purposes of a report, and I'm going to state and show exactly how. So Exhibit 4 to our opposition, Your Honor, is the May 2023 Digital Forensics Analysis Report of Jessica Hyde. And in that report, on page 3, she talks about, under forensic analysis, that she used, it's the exact same methodology.
What are you, I thought you said Exhibit 4. Exhibit 4 is a transcript. It's a transcript of Ms. Hyde, but it's not a report.
Okay, my fault, we have different numbering, but I'll go to the transcript. I'm going to go to the transcript with regard to it. So
I'm happy to look at the report if that's what you're referencing.
I'm
Where
going to
do I
go to the
find it?
report next, but if Your Honor's already at the, I can do it either way. If Your Honor is at the transcript, I'll go to the transcript right now. This is the June 14th transcript, Your Honor, of Jessica Hyde.
Yes.
Thank you. So we're just, and please keep in mind that in Mr. Hyde's 2024 report, that Mr. Whiffin's report that is now before you, Mr. Whiffin only used in his analysis now Celebrite Physical Analyzer and Ardex, his own tool. He only used 2 tools. Ms. Hyde, in her 2024 report, which I will get to, is now down to just using 1 tool, Celebrite Physical Analyzer, because she states that's the only one I was asked to look at. So the Commonwealth went and narrowed the request of Ms. Hyde to just Celebrite Physical Analyzer. And what is going on here? It's very obvious. The Commonwealth is ignoring in its 2024 December reports all the other tools. Even though those tools show this timestamp of 2/27/40 still, at that time, they now just ignore it and go to the Celebrite Physical Analyzer. That it's undisputed that Celebrite went back and changed it in the middle of the first trial with regard to one physical analyzer program. And then after the trial, the other physical analyzer program, they went and changed that and took it off. But in contrast, Axiom that Ms. Hyde used before still shows the timestamp. It's undisputed that that's the case. And it's undisputed because they don't contest it that Mr. Green went and looked at it in Microsoft, Sanderson. He did a manual, he did a low-level analysis, and in every one of those tools, the timestamp still occurs. So now back to the transcript. Your Honor, I am looking at, the question of, and this is, again, a significant point, is it better to use more tools? It's common sense. That's what Mr. Green says. That's what Ms. Hyde did the first time, but now all of a sudden she's down to just 1 tool that unilaterally removed the timestamp. So here is the page of the transcript of what Ms. Hyde had to say. Page 1-13, Your Honor.
Okay.
Line 4, question, again, of Mr. Lally. Now, with reference to the tools that you use that you just went through, are those fairly common tools? Are those tools that are commonly used within your industry? Answer, yes. And what are those tools that she talks about above? Starts on page 1-2. Celebrite Physical Analyzer, Magnet Axiom, Artex, iLeap, and I later used Sanderson Forensic SQLite. Those are 4 of the tools that Mr. Green used, and he used more. So her answer is, now with reference to the tools, are those tools that are commonly used within your industry? Answer, yes. They are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. It gets better for the defense. Next question, line 15. So different forensic tools, question, and why were you using the different tools? So different forensic tools have different capabilities and look at data a little bit differently. Skip down. Commercial forensic tools that they can only support so many applications, so they each work and support different bits of data. Here's the key point, line 22. This is Ms. Hyde's words, under oath. So it's important to use multiple tools so you can see the results from different data sets and be able to compare those results and enhance those with manual analysis. Next page. Question, and with respect to, and this will be the last question and answer, and with respect to using those sort of different variety of tools, Celebrite, to Axiom, to Artex, etc., is that something you typically do as far as your normal process of documenting a forensic analysis? Answer. Yeah, that is very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretations from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent And down below, he asked, can you explain the interplay of these tools in analysis? And her answer is strikingly the same as Mr. Green in his affidavit and in our opposition. Her answer, the Sanderson's tool, which Mr. Green and Ms. Hyde used, but Mr. Whiffen didn't, is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Mr. Whiffen didn't use the Sanderson tool. So here we have Ms. Hyde, and in her report of 5/23, 2024, her first report, and I'm going to get to her report here, she basically goes through and documents this methodology, and she documents the use of those tools. And she also documents that she saw the House Long to Die timestamp 22740 in every single tool that she used. Where she diverted from Mr. Green was her opinion as to whether that timestamp meant the search occurred at that time or did it occur sometime later. That's an opinion issue again, and Mr. Whiffen agrees in its opinion issue in that regard. So now let's come to where we are for this motion and what was submitted by the Commonwealth. And I want to first go to the report of Ms. Hyde now. It's Exhibit 4 to the Commonwealth's motion. And it's entitled Digital Forensics Analysis Report. And there's been much said in the Commonwealth's argument this morning about allegations made by Mr. Green, which are all supported. Every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Cellebrite Physical Analyzer, and it's gone, the search is gone, right? And we know why it's gone, because Cellebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Cellebrite Physical Analyzer? We don't know the answer. All that is stated is a bald conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools, where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Cellebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then Cellebrite had deleted in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Cellebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Celebrate just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 2:27:40 a.m. ET timestamp, the determination in prior analyses and from Celebrite is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Celebrite physical analyzer.
So are you telling me that we should have a hearing?
Your Honor, there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to look at, to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? Everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the NB postulate. And the NB postulate is, why are people using different tools, etc.? Is because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would a jury hearing do? We're just going to come witnesses and witnesses for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology. So what is it that caused Mr. Green to raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do, and that's what Mr. Green did. So there's great criticism of Mr. Green from doing what is proper for a digital forensic person, and it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Green say that caused him to say, I think it strongly suggests that there's been manipulation here? He used the fact that there's no hash value for the data. That's conceded. And when there's a issue over hash value, every single digital forensic expert is going to raise concerns about the validity of the data. And Mr. Whiffen is one of them who did that. Secondly, what Mr. Green pointed out on the issue of was this search deleted, there were 4,056 searches on the phone of Ms. McCabe. 4,056. There was one deletion out of 4,056, and guess which one it was? House long to die in the cold. There are no odds that that can happen randomly, that one search out of 4,056 is deleted. So what does Mr. Green say? He says that strongly suggests one of two things. Either there was user interaction deletion, or there was post-imaging manipulation of the data. He doesn't excuse individuals. He says user interaction or post-imaging. That is the job of a digital forensic person, to point that out and say that raises concern. The fact that there's only one deletion of a search out of 4,056, I think it's malpractice if a digital forensic examiner doesn't point that out. Another key thing he points out is an anomaly. The Commonwealth said there was a tab number for Hockomock Sports, in that they said it was the same tab number for how long to search or how long to die in the cold. But Mr. Green points out that's incorrect. They had two different tab numbers. So that theory of the prosecution can't be right. So Mr. Green wasn't hurling accusations. He was doing what data forensic examiners do, is pointing out all these anomalies. These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there is also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous, and he doesn't cite any. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where this search occurred. Well, that's interesting, because a harder thing to load, the image that came up with food, did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera. So you'll see two dates of the affidavits, and it's the later date, and I'm going to give you the specific one that controls.
No, I have both.
Okay, right, yeah.
The second one on the body of it does not say it's a supplemental or anything. If it was in the cover letter, that's what, they're both docketed, so they'll both remain
I was just going to
docketed.
say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why two, and it's a simple explanation, one supersedes the other. So Your Honor, in terms of, and this will be the concluding part of my remarks. In terms of the allegation that Mr. Green relies upon technical support at Axiom, and he relies upon technical support of Axiom, and a statement that is just remarkable, that that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis. He used the tools himself, but here's why he called Celebrite. At the time of trial, Celebrite had two versions of physical analyzer on the market at the same time. One physical analyzer showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Celebrite updated 1 week before a trial, didn't have it. So that was the insights, spelled oddly, INSYEES. That didn't have it. So Mr. Whiffen, or excuse me, Mr. Green did what any good digital forensic person would do. He called up support and said, well, you know, what's going on here? You got one that shows it, you got one that doesn't. But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Green's affidavit, says that good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people, you talk to their technical support. That's not someone inexperienced and relying upon them. That is the proper methodology. So Mr. Green did that to corroborate and get explanation for what he found. So in sum, Your Honor, here is what is before the court and what is pertinent for this motion. What is pertinent is the inquiry under Polk, which Your Honor cited in your decision on Dr. Russell. It comes down to, is Mr. Green qualified? There's not even a contest. Second, is his methodology reliable? And Your Honor, those are the only two subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now, Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing, where one party challenges the witness of the other, and then says, and oh, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person who.
I wouldn't say never.
Well, let me.
Yeah, I didn't understand that either. Why are you going to bring in? It's to see, the only reason to do a Daubert hearing is to see if that person is qualified enough to be an expert in a trial. Why do you bring in an expert from the other side during a Daubert hearing? That didn't make any sense. And then now Miss Bev says, oh, I wouldn't say never. Ugh.
Let me take that back. Good point. I won't say never. It is so unusual to have that happen under these circumstances. And this is the key, Your Honor. Why would we have a hearing about whether his methodology is proper and reliable if all of the witnesses agree what the methodology is? So, Your Honor, in conclusion, I would urge the court to deny the motion of the Commonwealth to exclude Mr. Green on one of 6 data forensic issues. He's going to be testifying, obviously, at this trial. And I would urge Your Honor to not have the evidentiary hearing, because Your Honor has before you everything Your Honor needs to perform the gatekeeping function. And again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Okay. Any follow-up, Mr. Brennan?
I do.
Of course you do.
A little bit of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that Mr. Whiffen's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search, misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone, for the user experience. And so there is cached items that are available without connection that register and come up quicker from a different source while it's waiting for a search to be conducted. It's simple. It can be explained. It's science. It's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts. What the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool, you can use 30 tools. They're all going to say on
The methodology is the same. Your experts use the same methodology that Green used. He just came up with a different opinion than your experts. Idiot.
the timestamp that how long to die in the code occurred at 2:27 on that browser. That is the time that was opened. That window was opened at 2:27. But you can't just look at 8 different tools that are all going to say the timestamp is the same. You have to look into the data and into the databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 2:27 starts counting after 6 a.m. in the morning. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's in addition to her 2023 report. Mr. Green has not written a report. He has not provided data. He has not provided that he has used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Green. There is none. Because if he actually does the testing and takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern.
I need to find that now.
The defense
I gotta
raises
get
this
one of those before the trial.
ideas. We never hear what the problem is. What is the hashtag value? Who manipulated it? And that is the MO. Blame anybody. Don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just posit a new theory. The government offers to bring in Jessica Hyde next week or even with at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case. And so we're happy to do it. We welcome it.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your
Okay.
Honor. Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
All right. Well,
There are 4 exhibits that have been logged.
thank you. So it sounds a lot like it may just be a disagreement in opinions, but for the Commonwealth, I will look more closely at your methodology arguments that were made today. If I decide that we need a hearing, an evidentiary hearing, and that I cannot decide this motion based on everything before me, I will let you know no later than Monday. Okay? So we'll keep
Yes,
next
thank you.
week and I'll let you know. All right. So, and Not that I would exclude something simply because it takes a lot of time, but we really need to make sure we keep this case on track for the April 1st trial. So I have a question for the Commonwealth on where we stand in discovery. And then we're going to talk a little bit about the motion to recover expert-related expenses.
Your Honor, we've been producing discovery as we've gone along to try to give the defense as much notice as we can. I had anticipated having discovery finished last week. We've sent over most of our discovery last night, or is in the process of being turned over. There was one further report. We've retained Dr. Wolf as a neurologist. I'm waiting for his report. He is away. And so my expectation is I can have that report by Wednesday.
Okay.
Further, there was a witness interview earlier in the week. I will have that report as well. My Rule 14 commitments are ongoing.
Why do they need a neurologist? Why on earth would they need a neurologist? Why? It's a car accident, supposedly. You're trying to prove it's a car accident. Why do you need a neurologist? What the fudge, man? What is this man doing? I had high hopes for this guy. I thought he was going to be better than Lally. Apparently not. Apparently not. But I do love Alessi. I didn't think this defense team could get any better. Boy, was I wrong, because this guy's amazing. Brennan is not. Brennan is on a witch hunt. Witch hunt is what Brennan is.
They are involved. Enormous amount of time over the months has been spent trying to satisfy that I can account for all the discovery and make sure the defense gets everything that I can as soon as I learn about it. We'll continue to investigate this case all the way to trial, but our discovery should be completed by Wednesday.
Okay. Does that include the analysis of the data from the Lexus?
That has all been turned over, or we're sending it over on link. Is something like 8 gigabytes on my expert, so it takes a long time to download. It was all sent to us yesterday. That's all included.
All right.
The
So,
analysis is done. The accident reconstruction is done. Mr. Crosby, with expertise in bites and dog bites, his reports are in. Ms. Hyde and Mr. Whitman have further reports that have been provided. Ms. Hyde has one more that's outstanding. We may have it. I expected it last night. I have not reviewed. And I think that accounts for. We've been through the entire amount of discovery that was prior. It has all been Bates numbers. It hadn't been before. It's marked as previously provided. I've made a very, very thorough accounting analysis with help of all of the information that isn't in those Bates numbers, and provided everything that I've come across as soon as I come across it.
all right.
Continue to look through all of our materials. There was an issue regarding a phone that we hired a third party to look through the phone and produce all Rule 14 discovery. I mentioned that my position was it was a very broad view that the assessor should look at. I was uncomfortable reporting to the court that the phone had been reviewed by somebody else, so I did it myself. And so I've gone through the entire phone, every email, every page, thousands, and I've provided not only Rule 14, but broad discovery. Pursuant to a protective order this morning to the defense, if they have anything that, from my perspective, from my experience, would be remotely important or interesting to them. Also, I've gone through well beyond my obligation emails of members of the Attorney's Office, and that continues.
Let's
And I
give
have
you
a
a
number of
gold
them as well.
star.
We call it Rule 14 because it's not necessarily statements of witnesses, but again, I've taken a very, very liberal and broad view of what I would
All right.
And so we do not have an official discovery order, but I'd like the defense to have the discovery meet 30 days after I complete mine, which will be next week.
Okay.
We filed, but I did not see on the docket, or we sent in, we did not file a motion for clarification, and Your Honor did not mention that. That's an important notice that we had sent in, because I am greatly respecting the April 1st trial date, and there's work to be done. And so I would like to address that motion, clarify when appropriate with the court.
Okay. All right. I'll need some time to review this, obviously.
Yes, Your Honor.
Okay. All right. That's great. So the Commonwealth expects to be ready for trial April 1st.
Yes, we do.
Okay. All right. So now let's just take a look at a preview, if you will, of the defendant's motion to recover expert-related expenses from the Commonwealth.
I should write
Okay.
all this.
I see there's a written opposition that I just received. We're not going to hear this motion today because I didn't have the opposition.
This motion is so good. I should have read y'all this motion. This one gets snarky. And she just said they weren't going to argue it today. We are definitely going to watch it whenever they argue it, because this one is snarky. And it should be, because dang, I can't remember the specifics, but they flew this dude out. What was it? Judy, do you remember? What was he supposed to look at? They flew him out to look at something, and there was no evidence to look at. I don't remember what it was. Shoot. I'm going to have to find the motion. We can read it after.
But one of the things that I'm hoping you can tell me before we hear this, all right, there are a couple of things. Let me just, in this motion, there's a footnote that references, so this motion from the Commonwealth was filed, from the defendant, was filed on January.
Well, I guess that's not going to happen. I can't look for an email without buffering the video. Never mind. Oh, the Sallyport video. That's right.
23rd. So more than a week ago, in the motion, I believe there's a footnote that highlights a pending motion to dismiss. I need that motion to dismiss. We need to get this moving. When will that? Well, I'd like that filed next week so we can hear it next week.
The reason that we haven't finalized it, the reason we haven't put the full contours on that motion is because we haven't received all the discovery. And I think it would be premature for us to figure out exactly what the parameters of our motion to dismiss are until we know exactly what the Commonwealth is putting in front of us in terms of the second trial. But as soon as we get that, we think that we have the grounds to bring that motion relatively quickly thereafter.
So you expect to have everything to the defendants by Wednesday?
I do, and really what's missing is a report from a neurologist, a witness interview that is really inconsequential. And Ms. Hyde has a report regarding a phone. That's all that's really left for discovery. So that's all I can say.
All right. So if you get it by Wednesday, we're here Thursday and Friday. I'd really like to see something by Friday. You've obviously been working on it, even if we end up having to do it in piecemeal. So
we've been thinking about it, but we have not. I don't know what you mean by working on it. Yes, obviously we're working that direction, but Your Honor, there's no way for us to reasonably get that done by Friday. That's just, there's so many other things that we're dealing with, including hearings like this that keep coming up over and over and over. I'm not. The court knows we don't drag our feet. As soon as we get something, we act on it. I just can't promise that we can get it done by Friday. We are working on it. And we're not
So be
There's
able,
no strategy for us waiting, I promise you.
be prepared to discuss it next Friday. I will be looking for it very shortly thereafter, and we will have a hearing on it very shortly. Time to respond.
Understood.
So we need to come up with a scheduling order, or I've got a scheduling order that we need to discuss. But regarding this motion, what I need to know before I hear the motion on the expert-related expenses is what sort of protocol you all worked out. Maybe it's in the Commonwealth's opposition that I just saw. What sort of protocol was worked out? Who was notified? What the arrangements were? How this all was set into play, and why there was a violation.
I can certainly brief that for the court. We addressed it pretty significantly in our motion in terms of the conversations that were had, the expectations that we had, the protocol in terms of getting our expert out there from
No,
Arizona.
what the agreement was, right? People don't just show up for the other side's expert. I just need to know what steps, what the agreement was for your expert to view this on that date.
Most of this was reduced to email. I think it'd be
Okay, so
probably
put
a little
it-
bit more accurate for me to just go back and file a supplemental brief.
Yeah, so
Probably
I
one
need,
page.
so I need all that information from such egregious conduct.
Sure, okay.
All right.
I'll submit a, that won't take very long at all.
Because then we'll address this next week.
Okay, that's fine.
All right. If we do not have an evidentiary Daubert hearing, do we need both days? Or does it make sense to schedule everything for Thursday? What's the Commonwealth's position on that?
Absent that, I don't think there are a lot of matters before the court. The motion for clarification should take probably less than 20 minutes.
Okay.
And the motion for fees is a very simple discussion. So I don't think there's any way we'd need 2 days unless there is actually an evidentiary hearing, and then it'll take some time.
Okay. What do you say, Mr. Jackson? You're nodding?
I agree. I think if there's an evidentiary hearing, it's going to take multiple days. If there's not, I think we can pack everything into Thursday.
All right, because I don't want to waste everybody's time. I want us to get this case moving.
Of course.
So you will then file that motion to dismiss the following Monday or Tuesday, and we need to set it up for a hearing. If you are indeed filing a motion to
I'm sorry.
dismiss.
The motion to dismiss on which Monday or Tuesday?
After we meet next week.
Following week.
Yes. I just want to get a scheduling order going, so I need some of these dates because we're going to need to schedule a hearing on that. I do not anticipate an evidentiary hearing on that, but I expect it will take time. All right, so the Commonwealth will have all of its discovery to you, it expects, by Wednesday, the 5th.
That's correct.
Okay. We'll be back here at the end of next week. After you have that discussion. And Commonwealth, I'll give you until the 14th to file an opposition to the motion to dismiss. And let's hear it the following week. We're also going to have to,
Oh, for crying out loud. I hope they're done on the 6th before 3 o'clock. I think that the Colin Griffith trial will be over by then.
the defense anticipate any evidentiary motions?
Yes, but I can't tell you exactly what those are, but in an abundance of caution, given the fact that we're expecting new information from the Commonwealth, I think the court would say
All right.
yes.
So February 21st, and I'll put this in writing. Filing of all evidentiary motions, that can be an out of court date unless we choose that day to hear the motion to dismiss. Why don't we figure out what's your availability the week of the 17th? The 20th is actually the best day that week for us.
Your Honor, that is, that week is school vacation week. Both Mr. Jackson and I have young children, but one of us, I think, could probably be here on the 18th.
On the 8th?
I'm muted and I'm yelling at my computer. Stop it. Stop it, stop it, stop it, stop it. How many days? Today's Saturday, Sunday, Monday, Tuesday, Wednesday, 5 days.
18th?
Right.
Yes, Your Honor.
Okay. Well, all right, so I'd like you to get me, can the Commonwealth get me the opposition by midday on the 14th? So I'll have it to review over the weekend. I know you haven't seen it, so it's hard to figure out how much time you need. Is the Commonwealth available on the 18th?
I'm available anytime.
Okay.
I mean, we'll put all our effort into it. If we have a problem, we could let the court know.
Okay.
We'll do our best.
Okay. All right. Okay, so the 14th will be an out-of-court filing date. The 11th, an out-of-court filing date. So the motion to dismiss hearing will be on Tuesday, the 18th. Filing of all evidentiary motions will be the 21st. And that will be an out-of-court date. We will do the hearing on all evidentiary motions March 4th and or 5th. I'd like you to block off both days at this point. And if we don't need them, we'll try and, I don't want everybody coming in for just one motion. I know how much work you all have to do to get ready for trial. There's a lot of work I need to do to get rid of trial, but I'd like you to block off those 2 days because we can't have motions to suppress going on and on past that date. I'm going to need some time to review them and write them. So, all right. Can you all come back in on March 7th? You'll file all motions in limine. We'll have a final trial conference. And then we'll have to set up a date for what I anticipate will be at least a day, maybe 2, because it was last time on motions in limine. All right, so March 7th will be an in-court date. And file all motions in limine. And at that time, I want you to tell me how long you expect your motions in limine to take.
Your Honor, do you want those filed by the 7th? All motions in limine filed by that hearing date, the 7th?
Yes. And on the 18th, which only gives me 2 weeks to decide them. Because we're starting the trial on April 1st. Jury Commissioner's Office has been fantastic about getting us as many jurors as possible. And we'll talk about impanelment, obviously, a little bit later. All right. All right. Anything else we need to discuss today?
Not on behalf of Ms. Reed, thank you.
No, thank you.
Okay. All right. Thank you all.
Push the wrong button. Jeez. So February 6th, 7th, the 18th, and then March 4th, 5th, and 7th. Was that all of them? Thank you, Judy, for telling me that, because I know it's not my fault, but you know how self-conscious I get. Because there are people. I'm always got people popping in and out, and they're thinking, why is this person even trying to stream with bad internet? That's probably why I don't have more subscribers than I do. They come on and there's a glitch and they're like, I'm out. And I don't blame them, but it used to work fine. And then StreamYard changed stuff. And now, ironically, I'm having internet problems everywhere, even when I'm not online streaming. So, because at first I was like, I feel bad that I'm changing my internet because I've always had good internet with them and they've always been very nice and they've always been quick to help if there's a problem. But now there's a problem even when I'm not streaming. It's all the time. Like when I was having trouble at the beginning, I had my iPad connected to the Wi-Fi. I disconnected my iPad and it got better. So, and the other night, I was trying to connect my iPad to the internet so I could watch YouTube on the TV and comment with the iPad, and I couldn't get the iPad to connect. And then Travis was watching YouTube in the living room. I was in the bedroom. He turned off the TV in here, and then all of a sudden my iPad connected to the internet. It's the season. I don't know, but I'm getting fed up with it. I'm at the point now that I'm still gonna mind a little bit telling him, but my biggest concern, and this is not me, you have a backup router that is it faster? Is it because of the router? But I don't want it because like our electric company just got this new like high speed internet. Just like redid all the lines and everything, and we're out in the middle of nowhere. And before, that's all we had was this internet that I have now. This is was our only option out here. So we've been on this for years and years and years. And before that, we had satellite, which was crappy. It had like a data cap on it. And I remember when my girls were little, Kristen loved to watch anime. She would stream anime. And then I'd go to watch something. And we only had them on the weekend, every other weekend because they were my stepkids. And then I would go to stream something when they weren't there and I wouldn't have any internet left. I'd have like very, very basic, slow, like dial-up speed. And and then I would be like, Kristen, what the heck? I can't watch anything because you were watching anime for hours when I kept telling you to get off the computer. Oh yeah, down there where you live, yeah, full of snowbirds. That's not real Florida down there. Not anymore, it's not. It's too many snowbirds. I mean, I was even thinking, because it's not a contract or anything. So I was even thinking of not saying anything to them and just not paying the bill so that if something happens with the new, then if I needed to, I could just call them and be like, I want to pay this month and then hook it. I don't know. I don't know. I don't know. But so that's next Thursday and from 3 to 5. So it's in the afternoon. So hopefully if that hearing is in the morning, it'll be done by the time they get here. Otherwise, we're going to have to take a break while they do it and then go back to the hearing when they're done. So let's see. Do we have anything else? There's probably other motions and stuff to read. Yeah, I wasn't going to call them right away. I was going to wait. I was going to wait and see before I called them. But like they might want their equipment. That's the only thing I was concerned about, was that they might need their equipment for another customer or something.
Go outside.
And I don't, it's like, I mean, it's not like a big corporation type internet, it's not like Comcast or anything like that. So I don't want this guy to lose his business, but faster internet for less money, that's a no-brainer. Come on, So if he can't compete, he can't compete. That's not my fault. Because like the speeds I'm going to get, he doesn't even go that high. And it's like $15 cheaper a month. So, I mean, like I said, it's a no-brainer. Unless he can find a way to compete with that. So, but I'm gonna wait. I'm gonna wait 2 or 3 months and see if I like it and it's all good and it fixes this problem. So, okay, well that wasn't as exciting as I thought. Well, it was exciting in spots. The motion was really, really good. The motion was good. He's 100% right. It's not about qualifications, and that's what a Daubert hearing's for. It's not about is he qualified. He's 100% qualified. And the fact that Miss Hyde or whatever her name is said you have to use more than one source. And then now she's turning around and only using the one source that no longer has that search on it it boggles the mind. I mean, come on. And people that are against Karen Reed are going to spin that somehow to make it seem legit. It's just not. Really? Oh, well then maybe I'll just leave it. I just won't tell them anything and just quit paying the bill, and then unless they call me, which they might, but they might not. Okay, well, I guess I will let you guys go. Oh, I wanted to say one thing though. You guys, my OGs, I realize that you guys saw this yesterday, and that you came back to watch it with me, and that just makes me very, very happy. Even though I'm not monetized, I don't have a bunch of subscribers. You guys you're always here, and you always have my back, and you wanted to watch it with me, even though you'd already seen it, and that's very special to me, and I love you guys. And I hope you're still around when I do get monetized, and that I just thank you for being here and watching the slowly growing channel that it is. I really appreciate y'all. So, Monday, 9 o'clock, Colin Griffith. I will see you guys then. Bye.
We're in trouble. There was a lot more than flying.